Welcome to the O'Connor Elder Law channel. I'm your host, Melissa O'Connor. I'm a Florida-based elder law attorney who does estate planning focusing on long-term care needs, commonly referred to as Medicaid planning, and I do probate, and I do it well. Today I wanted to talk to you about intentionally disinheriting a child or other relative. But before I do, I invite you to schedule a free strategy session with me at eldermeeting.com. So many times when I review people's estate plans, they indicate to me that they want to disinherit a certain child or a particular relative, and they express concerns when I mention that we need to purposely name that person and then state that we're not leaving anything to them. They would rather just not mention them, right? Because nobody likes confrontation. Nobody likes to be able to say, hey, I'm not leaving you anything. But it's best practice to avoid a will contest for you to name all your children. The classic example is that you have two sets of children, right? You have a child or children from a first relationship, and then you have children or a child from a second relationship. And you may then want to not leave an inheritance to one of those groups or one child from the group. And people have multiple different reasons why, right? Like they say, oh, they've inherited a bunch of money from their step parents, so they're set, or they have absolutely no relationship with that particular child, so they don't feel any affinity or need to leave them an inheritance. It really doesn't matter. I don't care why anybody decides who they're going to leave an inheritance to or not. It's none of my business. You can leave it all to charity. I don't care. But when we are drafting your will or your trust, it's important when we define and say, these are your children, that we name all the children. Every single person that, you are a parent to, right? And then we state, but for purposes of this document, whenever I refer to children, I'm referring to these people because I am intentionally not leaving any sort of legacy or inheritance to the persons that you are disinheriting. And that way, when it comes time to either probate your will or administer your trust, when the person that you're disinherited comes out of the woodwork, right, like looking for their inheritance, they don't have a claim to say, oh, that was a Scrivener's error. I'm sure that they either forgot about me or they just neglected to mention me to the drafting attorney. And for sure, I should have been included in the class of children because I'm a child. And so everywhere throughout the document that says I leave this to my children, they meant to include me too because I'm a child. If the document says intentionally we're not leaving anything to you, and we could write extra language in there as to why, or not for a lack of love or affection, we're not leaving you this, anything. It doesn't matter. Whatever you're comfortable with, rewrite it in there. But it's important that your estate plan document be clear that you intend to leave them nothing, right? That you remember them and that they're excluded. This will then make sure that there's less likelihood of a challenge in the future. Of course, anybody can sue anybody, but this will give the people that you want to inherit from you more sure footing to prevail should there be a contest. I hope that this information has been helpful to you. If it has, I ask that you like and share with others. And as always, you can schedule that free strategy session with me at eldermeeting.com. Thank you.